Okay, so this is the last lesson this week for our introduction material on what is law. Okay, now in this lesson, there are going to be a lot of terms to copy down. So please copy down the bold-faced terms. Okay, again, you're copying down your own notes, you're doing your own notes here, but please be sure you get the bold-faced terms down. Okay, so we started off defining what a law is. Okay, that it's there to be enforced by the government to regulate people's behavior in society. We talked about the goals of law, like the primary goal is to protect human rights, and how sometimes that leads to conflict because we need to respect the majority while protecting the rights of the minority. We looked at what human rights are, okay, and how they are protected. And then we ended up talking about the difference between criminal law and civil law. Okay, and we're going to hit those in detail as we move forward this semester. Okay, so today we're going to pick up with some more terms and we're going to pick up with some more concepts, some historical concepts dealing with law. Okay, now, first term is the term defendant. A defendant is the person accused of committing the crime. Okay? No matter if we're talking about a civil case or a criminal case, the person on trial is the defendant. Okay? The person accused of committing the crime is the defendant. They are on trial. In a civil case, the person that brings the charges is the plaintiff. Okay, the person or company that was harmed, they are against the defendant in a civil case. Okay, because remember, civil law is individual against individual. In a criminal case, the person that brings the charges that is against the defendant is the prosecutor. Okay. The prosecutor represents the state or federal government. In fact, they are the attorney for the state or federal government in a criminal case. Okay. So, in both types, criminal and civil, the person on trial is the defendant. In civil cases, the person that brings the charges is the plaintiff. In a criminal case, the person that brings the charges is the prosecutor. Now, there is a difference in determining degree of guilt. In criminal cases, you are found guilty beyond a reasonable doubt. Okay? The level of proof required to convict a person in a criminal case has to be beyond, you must be convinced 100%. Okay? All right. It does not, well, it does not mean convinced 100%, but it does mean there is no reasonable doubt as to guilt. Okay. We are going to see a movie for those of us that are meeting hybrid. We are going to see a movie called 12 Angry Men. Okay. And 12 Angry Men has to deal with this issue. If there is any doubt in your mind, like if you're in a jury and you're in a criminal case and the prosecution does not do a good enough job, in your opinion, then you should vote not guilty. Okay. Um, and this is pretty serious. Okay. So if you have any doubts in a criminal case, you have to vote not guilty. And the reason that is because we're dealing with more serious crimes. We're dealing with more serious punishment, including loss of life. Okay. So you have to be convinced close to as 100% as possible that the person committed the crime to vote guilty. Okay. If you are not convinced, then you need to vote not guilty. Now, in civil cases, the burden of proof is called preponderance of the evidence. Okay. Usually the standard of proof used in civil suit, the burden of proof that a party must meet in order to win a lawsuit. To win, the party must provide evidence that is more convincing than the other side's evidence. Okay. And we used the example of O.J. Simpson. In O.J. Simpson's criminal trial, there was not enough evidence to convict him of murder. Okay. The prosecution did not do a good enough job. The defense raised enough doubt in jurors' minds that they voted not guilty. Okay. In a civil case, because we're dealing with less serious punishments, as long as the plaintiff side produces more substantial evidence, they win. Okay. So in the O.J. Simpson case, the plaintiff's side brought enough evidence to show that his behavior and his actions led to the reckless deaths of Nicole Brown and Ron Goldman. And that was enough to find him guilty, and that was enough to get him to pay, okay, because the preponderance of the evidence. All right, so that's the standard of proof in civil cases. A defendant loses money in a civil case but can suffer lengthy imprisonment or even the death penalty as a result of criminal conviction. That's why there is a degree of difference for guilt. Okay, that's why in a criminal case, we already talked about it. That's why in a criminal case it has be beyond a reasonable doubt. In a civil case, it's just preponderance of the evidence. Okay, and those are some key terms. We're going to be talking about these a lot as we move through this semester. Now, where do we get our laws? What is the historical precedence of our laws? Okay, and I'm glad we're talking about it this week because Thursday, the 17th, is Constitution Day. Okay, and where do we get our laws? Well, we get our laws from the Constitution. Okay, so that's where we're going to spend the rest of our time today talking about our constitutional framework. Okay, our Constitution is the highest law of the land. Okay. Every other law that is made, laws that are made at the state level, laws that are made at the local level, cannot violate the Constitution. Okay. The Constitution is the rule that we follow. Okay. In fact, we use it, like I said, we use that to determine other laws. They have to fit in with the Constitution. Our Constitution is pretty spectacular because it is the longest lasting written Constitution in the world. Okay. It extends rights not originally written. I mean, that's one of the beauties of our Constitution. And I took a class this summer about our Constitution. I really have become more of a fan of it. The flexibility that the framers put in, because they knew there were going to be issues that they weren't going to have to deal with down the road, but they created a document that was both specific enough to deal with the issues at the time, but also flexible enough to protect these rights not originally written. Okay. And that's the beauty of our document. And that's why we have lasted longer than some others. Now, it does provide a framework for our government. We're going to talk about our government here the next couple of slides. Okay. It does provide a framework for our government. It lists the powers of the government. It lists the limits on those powers, and it protects the rights of the people, which is what law is supposed to do. Okay. And as flexible as it is, it cannot be changed without thought, discussion, and debate. Okay. Which, if you look at the political history of this country, we need to be very, very thankful for. Okay. That it could not be changed on a whim, or just because there's a change in who's in power, whether they're in Congress or the White House, that they could easily change the Constitution. Okay, the Constitution can be changed, which is good, but it requires thought, discussion, and debate. Okay, because we're dealing with the laws of the land, because we are dealing with important issues. Now, one of the most important principles within the Constitution is this idea of separation of powers. Okay, power exists between three branches of the federal government: the executive, the legislative, and the judicial. And later on, we're going to talk about checks and balances. Each branch controls the others. Okay, so that not one branch dominates everything. All right. And that is another special thing about our government. And one of the things that that is a direct result of the American Revolution, because we thought the king was abusing his power. We thought the king had too much power, and we did not want that in our government. Okay. So we created this separation of power, three branches with checks and balances between the three, so that power is shared and not one branch dominates the other. Okay. Now, let's look at these branches. Let's talk about the executive branch. Of course, the executive branch is the president, his cabinet, and his other federal agencies. Their job is to enforce the law. Okay? They make sure the law is carried out. Oftentimes, the president can issue rules and executive orders that have the force of law, but they are temporary, they are not permanent. If the president wants to issue something that is permanent, he has to work with Congress and he has to change the Constitution. Okay? So they can issue temporary rules and executive orders that have the force of law, but are not actually law themselves. Okay? The legislative branch, which is Congress, two houses, the Senate and the House of Representatives. The Senate has equal representation, 2 senators per state. The House of Representatives is based on population. The bigger you are, the more representatives you have. And that was done to pacify both the big states and the small states when the Constitution was being created. Okay, what is known as the Great Compromise. Okay, Congress is the Great Compromise. Congress makes the laws. Okay, it uses its lawmaking power to pass laws or statutes. So the executive carries out the law. Congress, the legislative branch, passes the laws, makes the laws. Okay. Then you have the judicial branch, which are the courts, principally the Supreme Court. The Supreme Court is the head court of the country, but you also have lower federal courts and things like that. Okay, their job is to interpret the law. Okay, so the executive enforces, the legislative makes, judicial branch interprets the law. Okay, it clarifies and in some instances establishes law through its rulings. Okay. So it interprets the laws of the Constitution, right? For example, okay, in the 2 most famous cases, Plessy versus Ferguson and Brown versus the Board of Education. In Plessy versus Ferguson, the Supreme Court determined that the Constitution, separate but equal was okay because it was not violating people's rights. Okay, that was one Supreme Court ruling. Separate but equal is okay. In Brown versus the Board of Education, the Supreme Court reversed itself. Okay, and said when we interpret the national law, when we interpret the Constitution, separate but equal, separate is inherently unequal. Okay, it is not constitutional. Now, with Brown versus the Board of Education, they were specifically dealing with schooling, but then the civil rights movement used that ruling to break down other forms of discrimination and other forms of segregation. Okay. So when we talk about the judicial branch interpreting constitutional law, it can be changed. All right. One court interpreted separate but equal as okay. It was constitutional. One court said, no, it is not. In fact, it is inherently unequal and it is inherently unconstitutional. Okay. But they interpret the meanings of those laws. All right. And there's my little half a picture there. It's supposed to be the Constitution being signed there. All right, now, like I said, back when we were talking about checks or separation of powers, with separation of powers comes this idea of checks and balances. Okay, checks and balances is the power to restrain the other branches. It prevents one branch from becoming too powerful and abusing its power. Okay, for example, okay, Congress makes the laws. But then for the law to go into effect, it has to be signed by the president. Okay, it has to go across his desk to be signed. And if the president doesn't like the law, he can send it back to Congress and say, I think you need to work on it. Okay, I don't think it matches up with the Constitution. Or he can do something called a veto. Okay, where he simply refuses to sign it. Okay, so this is an idea of check and balance. Again, separation of powers. Each branch has its own power, and each branch is prevented from dominating the others. Okay, veto power is an example of that. The president does not have to sign a law by Congress. Now, Congress, okay, if the president vetoes the power, or I'm sorry, if the president vetoes the law, and Congress says, you know what, I think this is a good one. We've worked really hard on it. I don't think we need to change it. Congress can override the veto, okay, by a vote. I think it's 2/3 majority, I think is what it is. But again, that way, if you have a Congress that is from a different political party as the president. That way you don't have a vengeful president that is simply refusing to sign laws because Congress doesn't match his way of thinking. Okay. At the same time, if Congress is coming up with some crazy laws, you have the president who can prevent them from getting enforced. Okay, he can veto them, he can sign them. Not saying he's going to prevent it forever, but he could send it back and say, "I really think you ought to take another look at this." Okay. Then, on top of all that, is judicial review. Okay, now judicial review is the court's power to declare a law unconstitutional. Okay, and what they do is they use the Constitution to judge the law, and if they say the law is against the Constitution, they will overturn it. Okay, so if Congress writes a law, it goes to the president and the president signs it and it is supposed to be enforced. If somebody challenges it before the Supreme Court and the Supreme Court says, you know what, you're right, this law is not constitutional, the court has the power to get rid of it. Okay? And that's another thing that is beautiful about our government. We got this system of checks and balances. All these different branches are supposed to be working together to protect the rights of the people. And all of them have powers to prevent the others from becoming too powerful and from abusing us. Okay. These are just two examples, but that's one of the beautiful things about our government is this system of checks and balances that goes hand in hand with separation of powers. Now, let's talk about, okay, if we get to the point where we determine a law is unconstitutional, what exactly makes a law unconstitutional? Well, number one, okay, it disagrees with the Constitution. All right, the government has passed a law, the Constitution does not give it the power to pass. Okay, if there is a direct violation of the Constitution out of the gate, that law is unconstitutional. Okay. Number two, if it violates somebody's rights, okay, and again, it has to apply to the actions of the executive and the legislative branch. All right. And your rights are protected by the Bill of Rights. So if a law is passed that violates the Bill of Rights, which is part of the Constitution, it's unconstitutional. Okay. Now, it's not a perfect system. Okay. I think, once again, using Plessy versus Ferguson and Brown versus Board of Education, one court interpreted segregation laws as constitutional because they said as long as the people have access to the same resources, okay, like a water fountain, all right, as long as both races have access to water, it's okay. All right, it doesn't violate the Constitution. It doesn't matter that the white fountain is better than the black fountain, okay, as long as everybody has access to water, it's okay. Now, if somebody doesn't have access to water, then it becomes unconstitutional. Later, a different Supreme Court says, you know what? That does violate somebody's rights. Okay, you can clearly see one water fountain is better than somebody else's water fountain, is better than the other water fountain, and that is a violation of rights. Okay, so again, if it violates the Constitution, it's unconstitutional. If it violates a person's rights, it's unconstitutional. And that's when the courts are going to step in and say it's got to be changed. Now, there's our Constitution with the little gavel right there. Now, a key concept with our Constitution is this idea of federalism. Okay, federalism is the division of power between the states and the federal government. Okay, it's to be honest with you, once again, it's appeasing those that wanted a strong central government and those that wanted strong state governments. Okay, the states and the federal government will share power. They will have jurisdiction over shared issues. Okay, then they will have jurisdiction over separate issues, like the states have more control over certain things, like education, for example. Okay, whereas some of your criminal cases could be in violation of state law, or they could be in violation of federal law. Okay. You could be tried at the state level, you could be tried at the federal level. Okay. But there's a division of power between the states and the federal government. This is the concept of federalism. Okay. And then you have the Bill of Rights, which is the first 10 amendments to the Constitution. It's part of the Constitution. It defines and guarantees your fundamental rights and liberties for all Americans. And it is there to limit the power of state, local, and federal government. Okay. All right. The people are supreme. The people's rights need to be protected. So the Bill of Rights is there to protect the people and limit the power of local, state, and federal governments. Okay. Now, I know I've thrown a lot at you these last three lessons, but that is the background that we have. That's the background that we're going to, these are the building blocks that we have as we move forward this semester, okay? We're going to be talking about these terms a lot. For example, the Bill of Rights here, when we get to the rights of the accused are defined in the Bill of Rights. It's important that we acknowledge what the Bill of Rights is, because they protect, if you are convicted of a crime or accused of a crime, your rights are protected in the Bill of Rights. So we're going to come back and we'll talk about the Bill of Rights later, okay? So we've laid the foundation for where we're headed the rest of this semester.